Welcome to the U.S. Department of Education and PTAC webinar entitled Data Sharing under FERPA. This webinar is geared towards state educational agencies and is designed to provide an overview of the FERPA regulatory changes and how agencies can remain in compliance with FERPA while sharing data to further the utility and usefulness of state longitudinal data systems. My name is Baron Rodriguez, and I'm the PTAC Director. With us today is Kathleen Stiles, the Chief Privacy Officer at the U.S. Department of Education. Among other areas, Kathleen oversees the Family Policy Compliance Office and the Statistical Privacy Advisor. For the Policy Compliance Office, Ellen Campbell, Acting Director, will be presenting, and Michael Hawes, Statistical Privacy Advisor for the Chief Privacy Officer at ED, will also be speaking to. The presentation will last approximately 1 hour. Yesterday, we ran this presentation by your peers from the state support team to generate feedback and any questions that came as a result of the training. If your questions remain after today's presentation, we encourage you to send those in to privacyta@ed.gov. That information will be available again at the end of the webinar, so if you didn't get that down, you'll see that on our last slide. The questions you send in may be used as a basis for future training or guidance documents. Participants should also note that within a couple of weeks, we'll post the archived webinar on the PTAC and the FPCO website along with the PowerPoint. Okay, so now you know who we are. We'd like to understand a little better who you are. We have several polls interspersed throughout this webinar to let us interact a little more. This is the first question. What answer best describes your connection with the educational community? Are you in early childhood education? Do you work primarily with K-12 education? Do you work with post-secondary education? Or do you not work in the education field? Second question is really about which best characterizes your experience with FERPA. Are you pro? Do you FERPA but find it confusing? You're at the point where you know what FERPA is, but you don't work with it often. Or those who are FERPA, what's FERPA? We'll see those a little bit later in the presentation. The agenda includes the following key topics. I'll cover disclosure of personally identifiable information from education records under FERPA and some of the key FERPA regulatory changes. Michael will discuss mandatory provisions and discuss best practices for data sharing, while Kathleen will provide some tangible examples through case studies written to provide guidance to agencies seeking to remain compliant under FERPA. We'll end the session with an overview of currently available resources from PTAC and FPCO. Okay, so let's start with the obvious. Why is education hosting this webinar? We recognize that FERPA can be complex, and we want to help entities with compliance. Mostly, we included this because we love the question. Officials meet weekly and talk through questions and responses, and we all enjoyed this comment. And to set the stage, but what is required for disclosure of personally identifiable information of education records? So the first thing you need to understand is that FERPA doesn't have any data sharing provisions. FERPA is a privacy and confidentiality statute. It's about access to student information. Talk about data sharing under FERPA. The term used under the statute and the regulation is disclosure of PI, personally identifiable information, from education records. I'm going to turn it over to Ellen Campbell now to explain some basics of FERPA. Ellen is a longtime PCO employee and has been the acting director of FPCO for 2 years. She has extensive experience with FERPA.
Thank you, Baron. When we talk about disclosure of PII from education records under FERPA, at the A level, we really mean redisclosure of that information, even though we use both terms. This is because the original disclosure happens at the school level or school district level when it discloses personally identifiable information, or PII, from the student's education records to the SEA on one of the exceptions to FERPA general consent rule. Typically, the exception in that scenario is the disclosure to authorized representatives of educational authorities in connection with an audit or evaluation of federal or state-supported education programs or the enforcement of or compliance with federal legal requirements relate to those programs. Under this exception, the SEA must protect the information and not disclose it in personally identifiable form to anyone other than pertinent SEA officials and authorized representatives. The SEA may redisclose PII from education records on behalf of the schools that provided the information under certain conditions, and it must destroy the PII when no longer needed. It's important that you understand the definition of PII, which works together with the equally important definition of education records, and determining what information must be protected from disclosure. PII includes not only direct identifiers, obvious items such as name, address, SSN, but also indirect identifiers that have the effect of identifying a student. So the standard is, can a reasonable person in the school community, someone without personal knowledge of the circumstances, identify the student? Education records are those records that are directly related to a student and maintained by an educational agency or institution or a party acting for them. At elementary secondary level, a parent has the right under FERPA to provide written consent before PII from education records is disclosed. When the student turns 18 years old or enters college at any age, he is considered an eligible student, and all the rights under FERPA transfer from the parent to the student. There are several exceptions that permit schools to disclose PII without consent, such as organization conducting studies and disclosures in connection with health or safety emergencies. An SEA may redisclose PII it has received from schools on behalf of its constituent schools if disclosure falls under one of the permitted exceptions to disclosure. In this recent amendments to FERPA, stated that an SEA may enter into agreements and redisclose PII on behalf of its constituent schools under the studies exception in FERPA. And under this permitted disclosure must be for the specific purposes listed here, and there must be an agreement in place. FERPA does not confer legal authority on an SEA to enter into agreements and act as representatives of the school. Nothing FERPA prevents them from doing so. Disclosures can be made notwithstanding the objection of the school, so long as the SEA has independent authority to have the study conducted, whether expressly or stated or implied, and makes the disclosure on behalf of the school. There's no bright line between what is considered a study and what is considered an evaluation under the audit or evaluation exception. Key to understanding the audit or evaluation exception is to understand two important new definitions that we'll talk about in a moment: as representatives and education programs. And in 2011 regulations, we refer to FERPA-permitted entities to mean those authorities and officials listed here. I have been referring to SEAs because of our audience today, but these principles apply to each of these entities listed on the slide. The studies exception only permits disclosures for certain types of studies, such as improving instruction. The audit evaluation exception does not restrict the type of evaluations that can be done, except that it has to be in connection with an audit or evaluation of a federal or state-supported education program, or to enforce or comply with federal legal requirements that relate to those programs, such as the state's responsibilities under the IDEA requirements. As I mentioned, it's important to understand the new definition of education program and its parameters, which Michael will talk about shortly.
We wanted to give you the first set of poll results, which answer best describes where you work in. It looks like the majority of folks on the call are from the K-12 sector. Approximately some odd folks from the post-secondary community. So it looks like the majority are K-12 and post-secondary. We do have some early childhood folks on there. The second one on where you are with FERPA looks like the majority of people are with, I work with FERPA but find it confusing. Would be consistent with the kinds of calls that we receive at the Privacy Technical Assistance Center. There's a couple of funny people that FERPA, what's FERPA, but maybe you were being serious, who knows? I've had some people come and ask me what that is. So with that said, we're going to move on to the next item. Thank you for your participation. So our poll is around your experience with data sharing. As you know, this webinar is really focused on the data sharing components around FERPA. So where would you say that you are? Do you have extensive experience with data sharing, some experience with data sharing, or have you never tried to engage in data sharing, maybe because of fear of the FERPA regulations, or just it is a very difficult process when dealing agency by agency, and we will get back to these results in a bit. That was some of the basics of FERPA. To frame our discussion today, we're going to now turn it over to Michael Hawes, who's going to tell us a little bit about the FERPA amendments and how they affect data sharing. Michael oversees the PTAC contract at the Department of Ed. He's a statistician and works on data release issues as well as overseeing the PTAC.
Thank you, Baron. The Department of Education published the final FERPA regulatory changes on December 2nd, 2011, and they went into effect on January 3rd of this year. These regulatory changes addressed numerous issues, including strengthening enforcement and helping to ensure the safety of students. With data sharing, the new regulations expand the requirements for written agreements and enforcement mechanisms to fit evaluations that can enhance program effectiveness, facilitate research into what works and doesn't, and increase the accountability of those receiving or accessing the data. While the presentation is about data sharing under FERPA as a whole, not just on the recent regulatory changes, I do want to take a moment to touch on some of the new regulations that are especially relevant to data sharing. In order to increase the accountability of those using PII from education records under FERPA's audit and evaluation exception, the new regulations now require written agreements between the educational authority disclosing the PII and the authorized representative that is receiving the data. The new regulations also introduce the requirement that the educational authority disclosing the PII must use reasonable methods to ensure to the greatest extent practicable the authorized representative is compliant with FERPA. The regulations also provide definitions for two key terms that you will hear throughout this presentation: authorized representative and education program. Before into some of the specific details of these changes and definitions, however, I want to point out that privacy and data access both exist on a continuum, and regulatory changes take a definite middle ground between being excessively permissive and overly limiting. Getting at the specifics of the changes, we start with defining the terms. What is an authorized representative? An authorized representative is the individual or entity that the educational authority has designated as authorized to conduct an audit or evaluation of a federally or state-supported education program. This leads directly to the definition of the term education program, which the regulations define as any program which is principally engaged in the provision of education. Broad term and can include early childhood education, elementary and secondary ed, special education, job training, career or technical education, or adult education. It includes any other program that is administered by an educational agency or institution. It's important to note, however, that under FERPA's audit and evaluation exception, PII can only be disclosed to audit or evaluate education programs that are federally or state-supported. With the new regulations, written agreements are now mandatory when sharing PII without consent under both the studies exception and the audit and evaluation exception. Agreements are often called by different names: iterated agreement, contract, memorandum of understanding, daring exchange agreement, etc. But regardless of what you call it, some form of written agreement is required to share data under these exceptions. In these agreements, we recommend that you consult the document Guidance for Reasonable Methods and Written Agreements, available on both the PTAC and FPCO websites, for details on what is required to be included in these agreements, as well as a variety of best practices for you to consider when drafting them.
Many states want to know what the requirements are for the written agreements under FERPA. The following slides will discuss the minimum requirements under the studies and the audit and evaluation exceptions. Remember, your state privacy or procurement law may require more stringent components around data sharing written agreements, and you should always consult with your procurement staff and/or attorneys to ensure compliance with state and local laws.
As mentioned a moment ago, written agreements are now required for sharing data without consent under both the studies exception and the audit and evaluation exception. Requirements for written agreements under both options are similar. The word of the specific requirements differs for the two exceptions. So look at what is required under each. Regardless of which exception you are using, however, it is important to know that these written agreements are critical to ensuring that all parties engaged in a data sharing arrangement understand their responsibilities and obligations for ensuring that the information is protected and used appropriately. So what's required for a written agreement under the studies exception? It must clearly describe the specifics of the arrangement, including the purpose of the study, and or it must conform to one of the allowable purposes that Ellen mentioned in her discussion earlier. It include the study's scope and duration, and it must provide a description of the data to be disclosed. It must also require the entity receiving data to only use the data for the purpose or purposes explicitly specified in the agreement, to access to the PII to only those individuals with a legitimate reason for access, and destroy the data upon completion of the study, and specifying a time period for that destruction. Audit and evaluation exception, on the other hand, written agreements must designate the entity receiving the data as the educational agency's authorized representative, must specify what PII will be disclosed and for what specific purpose. Remember from the definition I mentioned earlier that the purpose of a data sharing agreement making use of the audit and evaluation exception must be to audit or evaluate a federal or state-supported education program, or to enforce or comply with federal legal requirements that relate to those programs. This restriction, the written agreement must describe the activity in a way that makes it clear that it falls within the audit and evaluation exception. Agreements under the audit and evaluation exception must also require the authorized representative to destroy PII upon completion of the audit or evaluation, and must specify the time period for this destruction. They also establish the policies and procedures that will be used to protect PII from any further disclosure and from unauthorized use.
Agencies ask whether a particular approach is compliant with FERPA, and I have that in quotes. The fact is, even an approach is FERPA compliant, it may not be sufficient to adequately protect your data. It's very important that people understand that things can't be less than FERPA requires, but they can be more protective than FERPA requires. These are basic aspects that agencies should minimally consider as part of their written agreements, and you see those stated on this slide. Some practices around written agreement include the following. Maintain the right to audit. Make sure you regularly review policies, standards, and use of personally identifiable information to ensure compliance with terms set forth in the written agreements. Legal requirements. Stated earlier, FERPA is the bar. Your state and local laws and agency policy may require more stringent and specific requirements for protection of PII data. For handling a data breach. Many states already have laws requiring this. This is a best practice as inadvertent data loss is common. Review and approve reported results ensure that the data being released is accurate and does not inadvertently release PII, inadequate data disclosure avoidance techniques. Inform the public. Be transparent. Kathleen's going to talk more about that in a bit. Redact any security protection mechanisms, but let folks know that you do have agreements in place, and most importantly, that you have security procedures and policies in place to ensure the data is protected. What to do if your representative violates the written agreement? Look at the terms of the agreement in addition to the U.S. Department of Education enforcement. Contract remedies can actually be more flexible, so consider that as part of your path to take. Contact the Family Policy Compliance Office for any questions. So what are reasonable methods? This is a $10,000 question. Agencies commented on the reasonable methods FERPA section during the spring of 2011 notice of proposed rulemaking. Agencies wanted a clearly articulated path for how to appropriately protect data. Other agencies thought it could be cost prohibitive and or technically unfeasible should the department define in stone on the agency's behalf reasonable methods. Others thought that if defined, reasonable methods would be obsolete due to constantly changing security and technical advances.
I want to stress, nothing in FERPA compels you to share data. But if you choose to share data, you are required to use reasonable methods to ensure, to the greatest extent practicable, that the data is properly used and protected by the entity receiving it. This includes making sure that they are only using the PII for the authorized purposes detailed in the agreement, that they are properly protecting the data from further disclosure and unauthorized use, and that destroy data when the approved use has concluded.
Obviously, this is a complicated subject. The department has been working hard to provide states with real-world scenarios. They'll be called case studies in this case, to help navigate the changes of FERPA and the complex world of data sharing and longitudinal data systems. Cal will now walk us through some example case studies, starting with high school feedback reports.
We agree that FERPA can be confusing, and I'd love to talk through some examples. We developed these case studies at ED because we realize this can get a little confusing. We've tried to use real-world cases in our example. We'll be posting our first 2 case studies on the web, hopefully this week, and we have others that are in the middle of production. Today we'll be talking through 3 examples. We do anticipate producing additional case studies in the future. Let me stress that these case studies use fictional agencies and they do not address individual circumstances. And a caveat as we walk through the case studies that this is a FERPA webinar. It is not a webinar on all the laws that may apply to data sharing. When you think about these case studies and data sharing in general, be sure to consider other federal, state, and local laws. So for the first case study, the high school feedback report, assume with me that we have an SEA in a fictional state X. SEA has participated in the State Fiscal Stabilization Fund, the SFSF program. And accepting funds under SFSF, SEA has agreed to collect and publish various data, including data on student success in college, such as where they were required to enroll in remedial courses. So that the SEA, in this case, has a functioning K-12 state longitudinal data system, SLDS. The SEA therefore has data on all state X high school graduates. What the SEA needs to do is match those high school graduates to post-secondary performance data. Also with me that state X, that in state X, all of the post-secondary information at students of higher education, public institutions of higher education, is located in a higher ed governing board. We realize that not all states are set up this way. The situation for each of you in each state will be different. But for purposes of this example, the SEA has the benefit of having to go to only one source to get data on students at state colleges and universities. And this will be an ongoing program. The SEA wishes to obtain this data yearly, to house the data in its SLDS, and to conduct an ongoing program to evaluate and produce individual high school feedback reports. So included here handy diagram to show how the data might flow. And I want to include a note here that attended the SLDS conference in November, and one of the most helpful things for me was when presenters included slides with diagrams that showed data flows. We meet weekly with PTAC and FPCO and go over questions that come in, and we frequently have questions about what data is going where. So it's very helpful to us when you have questions for us, if you could even in a very simple way diagram for us where the data is going. So for example, starting at the top, you see the SEA and the Higher Ed Governing Board entering into a written agreement. The next circle to the right, the agreement will designate the Higher Ed Governing Board as the SEA's authorized rep. The agreement, of course, will do much more than that. It will specify the data being shared, how it will be used, how it will be destroyed, and other things. On the third box, the SEA will send the list of graduates to the Higher Ed Governing Board maintained by the IHE system maintained by the Higher Ed Governing Board. The Governing Board then conducts a record match to see which of the graduates are in fact in the HEGB system, and the HEGB then sends the SEA the performance information about these students. It could be enrollment data, credits earned, remedial class performance. It will be whatever is specified in the written agreement. So the next question is how to accomplish this. In this instance, the SEA uses FERPA's audit and evaluation exception, which allows the SEA to disclose PII, the graduates' names, to authorized representatives without consent to evaluate a federal or state-supported education program. This exception applies because the SEA is evaluating public high school instruction, which is an education program under FERPA. This is a two-way data flow. The SEA has to send identifying information on its graduates to the Higher Ed Governing Board, and the Higher Ed Governing Board has to send back information about those students. The SEA enters into a written agreement with the Higher Ed Governing Board, designating the Governing Board as its authorized representative. It allows the SEA to send the Governing Board PII on its high school graduates. The Governing Board matches the SEA's list with its own data and identifies students who enrolled in state X institutions of higher education. The Governing Board then sends information about these students back to the SEA. Prior to designating the Higher Ed Governing Board as an authorized rep, the SEA ensures, to the greatest extent practicable, that the Higher Ed Governing Board will comply with FERPA and use the SEA's information only for the purposes set forth in the agreement. The SEA consults the document we call Guidance for Reasonable Methods and Written Agreements, selects applicable best practices to safeguard the data. I really do want to highlight this document for you, which we've indicated is available on both the PTAC and FPC websites, as I think it will answer a lot of your questions on how to engage in data sharing. To be clear, again, you do not need to pick every method or activity identified in this document. You should select those that make sense for your situation. The SEA then uses the matched data and prepares high school feedback reports. Its high school feedback report to each of its LEAs for all of the high schools in the state. One question is why the Higher Ed Governing Board would agree to do this. I hope the Governing Board is interested in supporting the SEA because it recognizes the value of the evaluation for improving student preparation for college. But the Higher Ed Governing Board has a legitimate interest in making sure the SEA handles the confidential data appropriately. So the Higher Ed Governing Board requires that the SEA destroy the post-secondary data when it's no longer needed to evaluate SEA programs. Because the SEA will be including this data in the state longitudinal data system for preparing future feedback reports, the Governing Board does not require the immediate destruction of the data. Upon expiration of the agreed-upon data retention period, however, the Governing Board requires the SEA to certify that the data has been destroyed. Remember I mentioned that this is a two-way data exchange? Well, it actually only requires a written agreement for half of that transaction. Educational agency, the SEA is entitled to receive information about its students without a written agreement. The same is entitled to receive information about its students from LEAs in the state. But it would not make sense for the Higher Ed Governing Board and the SEA to enter into a written agreement that covered only half of the data transfers occurring between
them. And the Higher Ed Governing Board is legitimately interested in making sure the SEA handles its data properly. So the Governing Board and the SEA use best practices and enter into an agreement with two-way obligations. This agreement designates the Governing Board as the SEA's authorized representative. It specifies the data that will be sent in both directions. It specifies how the data will be used by both parties. It requires the destruction of data when no longer needed for the purpose specified, and provides a time period for that destruction. Establishes policies to protect the data from further disclosure or unauthorized use. So our next case study deals with the Head Start program, and it deals with data that is leaving the CA. So let's read the assumptions. In this instance, in State A, a local community action organization operates a large Head Start program for the city that's called XYZ Head Start. And this is fictional because when we first wrote this case study, we called it ABC Head Start, and we were told there is an ABC Head Start, so we shouldn't use them as an example. The majority of the Head Start funding for XYZ Head Start comes from the U.S. Department of Health and Human Services, HHS. The Head Start program does not receive funding from the U.S. Department of Education. The Head Start program wants to evaluate how well it is preparing students for school by obtaining information about its former students' performance in grades K through 3. Specifically, the Head Start program would like to receive data about its students from the SLDS, and it asks the SEA to share K3 data to conduct the evaluation. And assume for this study that State A has a functional state longitudinal data system with this data. The first thing that's important to the analysis is that the Head Start program is an education program under FERPA. It is primarily engaged in the provision of education, and early childhood programs can be educational programs under FERPA. FERPA audit and evaluation exception allows the SEA to disclose PII to authorized representatives without consent to evaluate state or federally supported education programs. Remember the prior slide that this program is funded by HHS. It does not have to be funded by ED itself. It just has to receive federal or state funding. The SEA enters into a written agreement with XYZ Head Start that designates XYZ Head Start as its authorized representative to evaluate the Head Start program. This agreement designates the Head Start program. It specifies the PII to be disclosed. It specifies that it is being disclosed to allow the Head Start program to evaluate itself. It requires that the data be destroyed when no longer needed for the purpose specified, and it provides a time period for that destruction. The agreement also establishes policies to protect the PII from further disclosure or unauthorized use. And yet one more time, I'm going to plug the guidance document. The SEA, being aware of its responsibility to use reasonable methods, make sure to the greatest extent practicable that XYZ Head Start uses the information appropriately, consult the guidance for reasonable methods and written agreements, and selects best practices to include in the agreement. In this instance, the SEA requires quarterly updates from XYZ Head Start on progress on its study plan. It reviews the organization's final report and conclusions. It requires written confirmation from the director of XYZ Head Start after the evaluation is concluded, certain that the data received from the SEA have been destroyed. The records disclosure of education records to XYZ Head Start and identifies the students whose records were disclosed and the reason for the disclosure. XYZ Head Start is receiving electronic information that is FERPA protected, consults and use the PTAC website and uses some additional resources available there. In this instance, the START program adopts some of the practices identified in the document Data Security, Top Threats to Data Protection. And as a further best practice, the organization establishes mandated data security training as recommended in Data Security and Management Training Best Practice Considerations. The next and final case study is intended to illustrate enforcement under the new regulations. We received a lot of comments in response to the Notice of Proposed Rulemaking about the 5-year ban, and we wanted to include an example that showed how it might work in practice. This study deals with an SEA that has decided to share data with outside researchers. The SEA is able to share data with outside researchers under the audit and evaluation exception. The agreement allows the research organization to use the SEA's data to compare the effectiveness of several different state-supported college prep programs used in different LEAs. For the sake of illustration, let's assume that the research organization is comparing the effectiveness of advanced placement, AB, curriculum to international baccalaureate, IB curriculums, to determine which program better prepares students for college. The SEA does what it's supposed to do. It takes steps to ensure that the research organization uses the data appropriately. It selects appropriate methods from the guidance document included in the written agreement. The organization uses data and produces a report that makes important conclusions about State X's AB and IP programs. The SEA, pursuant to its agreement with the research organization, reviews and approves the table in the report prior to publication to verify that cell sizes are sufficiently large so that the tables do not reveal information about individual students. Everything's golden and everyone is happy. But then, some months after the publication of the final report, the SEA discovers that the research organization did not destroy the data in question, but rather that it breached the terms of its written agreement and shared the confidential data with another researcher. They discovers this because another researcher contacts the SEA to ask questions about the data. This scenario has happened. There is no requirement in FERPA, in the law, or the regulations that the SEA notify FPCO in an instance like this. But we do consider it a best practice to be transparent. In this instance, for this case study, the SEA notifies FPCO. So we're glad that the SEA notified FPCO, but that's actually not the first thing the SEA should do. This SEA, being a good data steward, moved immediately to require the second researcher to destroy the data file that he improperly received from the research organization. The SEA follows up to make sure that the researcher destroys the data file. The SEA now knows that it has a problem with the research organization it shared information with, so it uses its right to audit. This right to audit was granted under its written agreement with the research organization, and audits the research organization's data handling practices. The audit is to make sure that no other violations have taken place and that the data has, in fact, now been destroyed. SEA also elects to pursue contractual remedies against the research organization, and I'd like to talk about that a little. It can be a blunt instrument. You data stewards should not be relying 100% on FERPA to ensure compliance with the entities you share data with. Contractual remedies may be much more tailored, more effective, and more timely than FERPA remedies. You're not limited in your data sharing agreements to the terms of FERPA. You could include in your agreements liquidated damages provisions. That means if the other party misuses the data, they can owe you money. You can include shorter terms for a data ban. You could, for example, have a 1 or 2 year ban for smaller infringements. You could require the other party to pay for notification and remediation in the event of a data breach. In this instance, the SEA has contractual remedies and it elects to pursue them. But again, they also notify FPCO of the FERPA violation and describe the actions they've taken. FPCO has been notified, so FPCO investigates the FERPA violation to determine whether the SEA took reasonable methods to ensure to the greatest extent practicable that the research organization was compliant. FPCO's investigation will focus on the SEA's action. Did the SEA take reasonable methods to protect the data? In this instance, FPCO notes some mitigating factors. FPCO notes that the SEA did not try to hide the violation and in fact notifies FPCO. FPCO notes the steps taken immediately after discovery by the SEA to the data. FPCO's investigation concludes that the SEA did take reasonable methods to ensure the proper protection of data by the research organization. FEO further determines, though, that the research organization breached the terms of the written agreement. Accordingly, FEO imposes a 5-year ban on the research organization. This ban provides that the SEA is not permitted for 5 years to act on behalf of the affected LEAs to share education records with the affecting research organization. This is appropriate because the LEA was acting on behalf of its LEAs when it supplied the data to the SLD that was shared with the research organization. So I wanted to conclude and talk about transparency a little bit. As you know, the Fordham Center on Law and Information Policy released a study in 2009 on children's education records and privacy. This was highly critical of the SLDS system and privacy. And one of the criticisms was that states were not transparent with what they were doing with student data. We agree that transparency is a best practice. Yes, FERPA allows SEAs to share data without consent. This does not mean data sharing should be hidden. To the contrary, we think parents ought to be able to find out what is happening with their children's data. The department encourages states to post sharing agreements on their websites. We encourage you to generally post information about how data is being used. Exceptions to FERPA allow data sharing for audits, for evaluations, for studies, etc. So if you're sharing data for these purposes, you should publish results. If you're doing good work that is sharing important information and results, you should hide it. We encourage you to publish it.
What additional resources are available? We talked about the legal requirements and best practices for data sharing, and we've talked through some examples. But this will really not answer all of your questions. Your important takeaway today may be references to additional resources. First of all, the Family Policy Compliance Office administers FERPA, the Protection of Pupil Rights Amendment Act, PPRA, and the military recruiter provisions in the Elementary and Secondary Education Act. That the FPCO is a resource to states to use. So if you have questions, please do send questions into them. In addition, the Privacy Technical Assistance Center is really designed to be a one-stop resource for educational data system stewards for information about privacy, confidentiality, and security issues. Our audience is really focused on local education agencies, post-secondary institutions, and those of you here on the phone from state educational agencies. Our resources include regional meetings. We have several regional meetings that we'll be conducting over this year. We have lessons learned forums. We'll be at the MIS conference talking about different topics, them being statistical suppression techniques, as well as the FERPA changes. We have webinars such as this. We will be doing monthly webinars. We'll be talking more about those in upcoming slides. And we also offer technical assistance site visits, as well as our help desk. We all have available resources currently on the web right now. We have technical briefs, briefs on a variety of security and privacy topics. We will be publishing more of those over the next 5 to 6 months. We will be posting the case studies that Kathleen has talked about today. We have security checklists, which you can use as a guide to help you create some of these agreements. We have frequently asked questions, webinars, presentations, and training materials. All will be posted on the PTAC website. So please check there. We usually have new documents going up at least monthly. Sometimes as the spring comes on, we'll probably have them coming on more frequently. So I said earlier we're going to talk about upcoming webinars. You see in February we will be having a webinar specifically focused towards colleges and universities to provide the FERPA basics. It's really geared towards the post-secondary community, but you are welcome to attend as well. And we encourage you to notify folks in the post-secondary community that this is coming up. To get to this, just go to our website and you can register for it. Make sure you register early. We are limiting, for audio reasons, only 500 attendees, so please do sign up early. And in March, there's been quite a few requests come into the Privacy Technical Assistance Center help desk, specifically around special education and FERPA and the intersection between IDEA. We'll be talking more about that. The date has still not been set, but we'll be getting back to you. Check frequently at our website to see when that gets posted. As we explained at the outset, we're really in a position to take questions on the fly in this forum. Aside from the issues of the number of participants, we found that FERPA data sharing questions tend to be quite complex and quite fact-dependent. What we did was a dry run of today's presentation before some of your fellow peer state support team members and solicited questions from them on your behalf. Many of the offered, we've selected 3 to answer today. The question is, I'd like guidance on the written agreement requirement. Do you have a template agreement I can use, or will you review a draft agreement for us?
This was a really good question, and it's a comment that we have gotten to PTAC and to FPCO and to myself personally as well. We are preparing a template agreement. I just want to highlight that I anticipate it will be more in the format of a checklist than a true template, and a couple reasons for that. And some people have asked us to review individual agreements, and we're not in a position to do that. We're not in a position to do that because of staffing issues and because our lawyers represent Ed and not you all in the audience. Additionally, our lawyers, neither our lawyers nor us, are up on the state laws that affect individual agreements, but we do think we could be more helpful in this regard, and we are going to prepare a template. And until we get that template prepared, I want to flog even harder the document guidance for reasonable methods and written agreements. There are some suggested contract terms that are in the document that may be helpful. Again, you're not going to need every suggested provision that's in that agreement. You need to look to what's going to fit your particular situation.
Second question is, does FERPA permit data to be shared across state lines? I want to gauge data for former students from another state.
This is another question that we get fairly frequently. FERPA does not make distinctions based on state lines, so an SEA could designate an entity in a different state as an authorized representative for the purpose of conducting an audit or evaluation of a federal or state support education program.
Final question is, your school feedback reports shows an SEA getting data about students attending public colleges. But what about students at private colleges and universities?
The questioner in this case is quite right. SEAs will want to obtain the most complete information possible about their graduates. In states, the majority of high school graduates will attend an in-state public college, but in other states, this may be a fairly small percent of graduates. The process, however, is the same. SEA would enter into a written agreement with the private college. The fact that FERPA permits this data sharing, however, doesn't always mean that the private college will want to share data with you. But institutions sometimes do not have the same incentives for data sharing as public institutions do. My experience has been that data sharing works best when the benefits flow to both sides of the equation. So regrettably, if private colleges do not want to share data with you, that's not a problem that our statute or regulations are going to be able to help you with.
Thank you, Kathleen. And now we're going to share our earlier poll results around experience with data sharing. And as you can see, most folks have some experience with data sharing, and then we have a few that have never tried to engage in data sharing. But for the most part, there's a fair amount of experience out there with data sharing. So that's good to know. We are going to ask another poll now from you, and this is going to help us with our future trainings as well. And to produce additional case studies. Please view this list and select the one that you anticipate will be most helpful to you. The first one is a case study illustrating what is and is not an education program. The case study illustrating schools receiving PII about former students. Study illustrating the intersection of FERPA and IDEA, illustrating how an SDS can receive workforce data, or finally, nice try, but I have another case study in mind. And if you do that nice try, if you could send your suggestions to privacyta@ed.gov, we'll also take those into consideration as well. We're going to go ahead and start that one. And then finally, we want to know how helpful you found today's webinar to be. Was it very helpful, somewhat helpful, or not all helpful? We're very much open to your feedback, and we look forward to hearing how we've done on this webinar. Again, thank you for attending today's webinar. As stated earlier, please do send your questions in for consideration for future trainings and issue briefs. If we don't get it in a training, it may be something that we address either through a case study or an issue brief. But we do look forward to continue hearing from you. And thank you again, and thank our panelists today for their presentation.